Thank you for tuning in to today's media briefing on the federal erosion of business civil liberties. Washington Legal Foundation is pleased to have a couple of special guests today to discuss the overcriminalization timeline that we are officially launching today. The first of these is Jay Stevens. Jay recently retired from Raytheon Company after serving for nearly 13 years as a member of the company's senior leadership team, including as Senior Vice President, General Counsel, and Corporate Secretary. Prior to joining Raytheon, Mr. Stevens had a distinguished career in the public and private sectors, serving as Associate Attorney General of the United States, the third highest position in the Department of Justice, as United States Attorney for the District of Columbia, as Deputy Counsel to the President of the United States, and in the private sector as Deputy General Counsel of Honeywell International, and as a partner in the Washington office of a leading national law firm. We're pleased that he now serves as Chairman of Washington Legal Foundation's Legal Policy Advisory Board, and we look forward to having his perspective today, both as a former prosecutor and as a former General Counsel. We're also pleased to have Norman Reimer join us today. Norman is Executive Director of the National Association of Criminal Defense Lawyers. Mr. Reimer leads a professional staff based in D.C., serving NACDL's approximately 10,000 direct members and 90 local, state, and international affiliate organizations with up to 40,000 members. Prior to assuming this position, he practiced law for 28 years, most recently at Gould, Reimer, Walsh, Goff & Cohn. Mr. Reimer was previously president of the New York County Lawyers Association, one of the nation's largest and most prestigious metropolitan bar associations. He is also publisher of the Champion magazine, and we were delighted that NACDL partnered with us on this timeline and helped to greatly expand the distribution of it by including a copy of the timeline in the latest edition of the Champion magazine. So I wanted to say thank you publicly for that, Norman. Really appreciate that. So let me turn things over now to Jay for a few remarks, and then Norman, and then I'll say a couple of things, and then we'll throw it open to questions.
Thank you very much, Mark. I appreciate the opportunity to be here. Norman, delighted to have an opportunity to share this time and the platform with you as we discuss the timeline that the Washington Legal Foundation has put out regarding overcriminalization. I really want to commend the operation of the Washington Legal Foundation for doing this. I think this is a very important highlighting of a series of trends that you see in a range of policy and practices and legal developments in the area of prosecution and criminal law. And when you look at it from a holistic point of view, I think you can see where the concerns can lie with regard to the potential erosion of civil liberties, and what we've seen, what I think many of us would believe is sort of the overcriminalization of what's going on in our society, in our business, in the society in general. I think at the outset, I'd like to just make clear from my perspective at least what this is not about. This is not to suggest that we don't think it's important to have aggressive, vigorous prosecution of the criminal laws. It is important, and having an effective criminal prosecution program is important for the integrity of our governmental process, for our economic processes, and for our individual relationships, and for the safety and security, obviously, of our citizens and our society. And it's particularly important as we move and become a more global economic in a global economic environment, so that we can maintain a level playing field for businesses that operate and are formed and are rooted in the United States. Secondly, what it is not about, and what I think we want to underscore and emphasize, and this comes perhaps from the other trend and background of my own personal experience, is that it is important to maintain effective compliance programs. It's effective to maintain aggressive and good codes of conduct that are not just on paper, but that organizations, particularly business organizations in the United States, have effective compliance programs so that they can comply with regulatory requirements as well as obviously with the criminal law. I think what I would like to suggest, so if we can still have an aggressive criminal prosecution program, we still have very effective compliance programs. But when you look at the trend lines and when you look at the holistic view of where things have gone and are going or appear to go, why it's important for organizations like the Washington Legal Foundation and others to stand up and understand where we move beyond the boundaries and where we are over-criminalizing our society. And it's particularly the case, I think, in what I would call the regulatory environment or the administrative state. And the consequences of these are significant. So we've moved beyond sort of intentional criminal acts and the prosecution of that to using the criminal process as a regulatory tool to drive regulation. And there, I think, you start seeing changes in what constitutes intent. You see changes in how the process operates. You see changes in prosecution policy, and a range of things that start to suggest that the criminal law is just another regulatory tool, and it doesn't occupy what many of us would suggest is perhaps the really pristine role of the criminal law. And I'd just like to take a moment to go back to the fundamental concept for all of us who studied law and for all of those of us who have been exposed to law. I think we have a sense that, the criminal law and being charged with a crime has a particular meaning. It is society casting its moral opprobrium on a particular pattern of conduct or act or criminal act. And it has with it a sense of the requirement of having some clarity, having some intent, having the actor be accountable for his or her conduct and actions. And that, if everything in our society becomes a crime, it changes the whole dynamic of what it means, because we will have a society effectively of everybody will be branded as a criminal. And it also changes the tenor and tone of the debate that goes on in the economic debate, in the political debate, in policy debates. If disagreements all inherently or automatically ramp up to sort of accusing the opponent who disagrees with you or has a difference of opinion, accusing them of being a criminal, it just changes the whole dynamic dramatically. So I just as a cautionary note, I think it is important in our society that we stay with a touchstone to what it means to where the criminal law, what the roots of the criminal law are, and how they are enforced as we go forward. So there are different standards, as we all know, in criminal law. There's a different standard of proof beyond a reasonable doubt, and there's different standards as to when an individual is accountable. A lot of the issues that we're talking about in the timeline come up obviously in an organizational context, in an enterprise context, as to how you established accountability, liability, and responsibility with regard to an organization. But it's important to remember the criminal law is different. And if we say, well, if we start to merge what I would say tort law with criminal law, it gets to be problematic. So if the tort theory is for every wrong there must be a right, and we're going to right that with some kind of tort action, in the regulatory area, for every wrong, it doesn't necessarily have to be a criminal prosecution. There are alternative ways to deal with that. There are administrative remedies, there are civil remedies, and indeed those can become more effective in managing the regulatory environment, and they certainly are important from a legal process in terms of the tone and the benchmarks and the timelines that we apply in our enforcement environment, so that we don't make everything a crime. There are alternative ways to deal with this. And from a policy point of view, from a big picture point of view, this also is concerning, I think, because it really inherently involves a shift of power to the government. And the government, almost by definition, is the monopoly player in the criminal enforcement. Individuals do not enforce the criminal law. The government enforces the criminal law. So the extent to which everything becomes a crime, every action becomes a crime, and the government is the monopolistic enforcer of that, it obviously shifts power there. And when we see how the criminal law can be and has been and may be enforced, we just want to step back and be cautious, because a lot of these changes in the process means mean a shift of authority and power and leverage to the government. We have less judicial oversight, more administrative law making by prosecutors, by regulatory agencies, by the Department of Justice. And they are, because individuals and or enterprises can't always challenge that. They can't take the risk, they can't afford the costs, and so cases don't go to court. Cases are not tried. Decisions are made administratively, and the law develops administratively, and inherently that means a shift of power to the government. Likewise, the use of deferred prosecution agreements and non-prosecution agreements. On their face, they can be seen, I suppose, as a lifesaver and a real raft to an enterprise. Instead of being charged with criminal conduct, it becomes almost a probationary kind of administrative process. But in reality, while it does that, it also extends the power of the Justice Department, for example, or other agencies that may be involved with these, extends their power into the enterprise, because it uses, whether it's a monitor or whether it's the general counsel of the company, it extends the leverage on how we control and manage the enterprise. And as a consequence, that also has the capability of shifting power and authority and overall management and perhaps even intrusion into private enterprise and the businesses. Yes, they can have very effective, positive outcomes, but it's something I think we have to keep very cognizant of how we manage that and how we shape those as we go forward. So underlying all this is this concern about the individual and individual enterprises and the shift of power to the government. And as you look at as the timeline that the Washington Legal Foundation has developed, you see some of the fundamental issues here where things have changed over time. In the mens rea area in particular, I mean, we almost all intuitively think about crime as sort of, well, there's an intentional act that someone did to violate a law that was very explicit. And that's something I think we probably take away from law school. But we see that has changed significantly when you get into the regulatory environment. And the fact that we have 4,500 or more criminal laws suggests that, you know, for every act, for every change, for every ill in society, there becomes another criminal penalty. And as a consequence, the standards that are being applied, is it intentional? Is it knowledge? Is it responsible corporate officer? Is it blind indifference? Is it collective knowledge? And each of these become a mechanism to sort of ratchet down the individual's accountability. And I do think, as we look at enforcement, the individual's accountability is important, because organizations themselves don't act as an organization. There are individuals within an organization who are making decisions and judgments that may cross the line, and it is there where the accountability should be held. So we have a proliferation of laws, we have a change of standards that are applied, we have impact on attorney-client privilege, something that has been a key component of sort of the role of law in our society and the rule of law, and the extent to which changes in prosecution policy, or, for example, if we change the prosecution policy where the company is required to investigate the individuals within its company who may be accountable or responsible, and then provide all that information to the enforcement agency. That has some serious implications for the attorney-client privilege. It has some implications, obviously, for the rights to the individuals, to their counsel. It is leveraged, again, this is a means, unless you do this, we won't credit you with cooperation. So these are all things that sort of start to chip away and undermine of where we are. So if you look at attorney-client privilege or Department of Justice prosecution policies, et cetera, I just want to underscore here, we all want to be sensitive to how we can start eroding the power of the individual, the role of the individual, and how that is done by chipping away at each of the areas that the Washington Legal Foundation has highlighted. So, you might say, well, what can we do about this? I think Washington Legal Foundation obviously operates in this area where it can litigate and where it can communicate and where it can share legal value and legal theories as to how we can modify areas that perhaps are achieving overreach in this area. The Congress, obviously, it is the one who enacts the laws and ensuring that we have clear intent standards so that it isn't just everything that anybody is accountable, whether or not they even had any knowledge or any relationship to the offense. The Justice Department and its prosecution policies, the discretion, prosecutorial discretion, how is that exercised, and what is the role of the judiciary in sort of balancing and managing some of that executive authority when it comes to impacting the rights of individuals and businesses. And how do we resolve matters? These all impact, whether it's through deferred prosecution agreements or individual prosecution or prosecution of an enterprise. How that is accomplished and done really does impact sort of the sense of, is everybody in our society a criminal just because there is a regulatory infraction or a regulatory violation? Are there superior ways to deal with this? And I would submit there are superior ways. In a regulatory context, the administrative remedies, while they can be very draconian, if it's suspension or debarment or suspension of an individual's ability to serve as an officer of a public company, for example, those are very significant. And civil penalties. So the standards are different, the message is different, and they are alternatives to just prosecuting everyone for activity which we think, gee, there ought to be a law against that, so let's make it a crime. And then I want to underscore, in conclusion, that it is important to continue for folks who are part of business enterprises to have strong, effective compliance programs. That is part of the regulatory environment. So this is not a suggestion that gee whiz, overcriminalization, the alternative to that is a country of scofflaws, au contraire. It suggests that there are better means, there are alternative means, and there are more appropriate means to ensure regulatory compliance where those regulations are enacted by society to achieve societal purposes. So I, again, just thank very much the Washington Legal Foundation for making this effort, taking this effort. I think it's a tremendous importance to shine a spotlight on this area so that we continue to exercise care and caution as we move forward in this. Thank you.
Thank you very much, Jay. Norman?
Good morning. Thank you very much, Mark and Jay, for your outstanding remarks. I, too, want to congratulate and salute the Washington Legal Foundation for producing the timeline, the federal erosion of business liberties. It's really a remarkable tool to have at our disposal. And as Mark mentioned, we were very, very proud to include that as the centerpiece of our recent edition of the Champion magazine. So let me get a plug in for that. For those of us who are concerned about overcriminalization in this country, the timeline, the third edition of the timeline, was really like an early holiday gift. They say that a picture is worth 1,000 words, and that is so true, especially when you're trying to fight something that is very often difficult for so many to visualize or grasp. And although the timeline may not exactly be a picture, it is in many ways even more effective because it shows, as you expand it out, a trend. And I think that's what Jay was referencing. Also, this inexorable trend that has brought our society to what I feel is a dangerous tipping point. It's a place where overcriminalization threatens not only the economic health of our nation, but the core values that sustain us as a diverse and innovative nation. I represent an organization that has profound concerns about the broad misuse of the criminal law. We seek a criminal law that is more rational, more humane, and far less expansive. We have special concerns about this expansive use of the criminal law and its impact on small businesses that are the engines of American growth, and as importantly, on the individuals who propel small, medium, and large-sized businesses. The people who are the engines of this growth are at risk because of an unbridled growth in the expanse of the criminal law and how the government uses and abuses that law. But let me be clear about one thing. Just because we are the criminal defense bar, we do not condone criminal behavior. Of course, we will fight for the dignity of every individual, whether they are guilty or innocent. The Sixth Amendment to the Constitution is pretty clear and pretty absolute and pretty amazing, actually. It says that every person charged with a crime has the right to the assistance of counsel. This is an ingenious gift that America gave the world. It applies to the innocent, it applies to the maybe innocent, the partially guilty, and the guilty, because it is a matter of human dignity. Nobody should ever stand alone against the full force of the government when the power of the prosecution, which is in many respects the most awesome use of power short of warfare, is brought against them. But we also understand and recognize, as Jay acknowledged, that when people break the law, they have to pay a price. But they should be only paying that price when they are doing something that is truly bad, truly wrong, and done with a purpose and a knowledge to break the law. But in several fundamental ways, the criminal law in this country is now becoming untethered from its moral anchor. The timeline vividly describes and depicts how that has happened and how abusive the use of the criminal law has become. I want to just address, I think, 3 of the 6 points that are projected in the timeline. First, the proliferation of criminal laws and sentencing developments. Numbers do not lie, and we have some pretty stark numbers that are staring us in the face in this country. And they too paint a very vivid picture. First of all, 2.2 million. That is the approximate number of people who are in prison in this country. This nation leads the world in incarceration, both in actual numbers and in per capita. We are arresting 14 million people a year. We now have approximately 70 million adults in this country that have some kind of a criminal record. And they face what the ABA has documented as being more than 50,000 collateral consequences that will haunt them for the rest of their lives. Now, I submit that with all of this criminality, we have to answer this question. Are we a nation of bad people? Are we a nation of evildoers? I don't think so. I think we are a nation that has made some bad policy choices. We have turned to our criminal law to regulate all manner of disfavored social, personal, and economic behavior. And as a result, we're dealing with these kinds of numbers. And when you look at another set of numbers, Jay mentioned that we now have approximately 4,500 federal criminal statutes. That's just federal criminal statutes. But look at that in a context which the timeline helps us with. Timeline doesn't go back to 1800, but I am told that in 1800 there were approximately 50 federal criminal statutes. The timeline starts with 1900 when there were 165. By 1970, it was 2,000. By 98, 3,300. And now we are at this place of 4,500 or more, and another 300,000 or 400,000 criminal penalties that are in regulations. No one has even been able to count them. There are so many of them. And of course, during this entire time, there has been a geometrical increase in prison sentences and mandatory minimums. We have actually turned the criminal justice system into one of America's biggest businesses, and in so doing, it has created a climate in which pursuing legitimate businesses is at risk. The second abuse, and Jay also spoke very eloquently about this, but this is one that we have been really concerned about for a very long time, is the failure to ensure adequate intent requirements. Intent requirements are the principal moral anchor of the criminal law. It is unreasonable, it is unjust, and it is immoral to hold a person accountable for criminal behavior if they don't know they're committing a crime. But that is what is happening with businesses and with individuals in this country. Going back to 1909, when the concept that a corporation could be held liable for the acts of an errant employee The emergence of notions such as the responsible corporate officer doctrine, public welfare offenses, and judicial engrafting onto vague statutes such concepts as willful blindness or conscious avoidance, all of these are meager substitutes for the requirement of having an intent to commit a crime. The timeline traces a sordid history of assigning criminal liability despite the lack of knowledge or intent. Finally, I am happy to say there is much talk in Washington now about criminal justice reform. It is long overdue. It is welcome. It's probably the only area where we see a bipartisan consensus beginning to emerge. It is critical as we go forward with these reforms, especially for the little guy who can't afford cadres of high-priced lawyers to analyze every statute and regulation. It is critical that we produce meaningful reform that will ensure that every criminal statute and every element of a criminal statute has a precisely defined intent requirement or a default intent requirement that applies to every element of every offense. We have to stop this sort of willful blindness in our lawmaking to ensure that we have those safety measures in place, and nothing less will do. Third and final problem addressed in the timeline that I want to address, and really this is a pet peeve of mine, is the overly broad misapplication of the criminal law to apply in situations, often commercial but not always, that have absolutely nothing to do with the purpose of the criminal statute. A year or so ago, we had the Yates case, where a commercial fisherman who allegedly threw back three undersized grouper, he was in violation of a fishing regulation, wound up getting charged with a federal crime under the Sarbanes-Oxley anti-shredding statute, facing 20 years in prison for throwing back three undersized grouper. That's wrong. Fortunately, the Supreme Court narrowly agreed that it was wrong. But that's the kind of thing we're talking about. A few years ago, we had a case called Brigham Oil, in which the Migratory Bird Treaty Act was used to prosecute oil company executives because birds flew into perfectly legal oil drilling reserve pits. Another case where the Supreme Court had to step in, which doesn't involve businesses, but shows you how prosecutors can misapply these laws, was a situation in which a woman put a caustic substance on the doorknob or the mailbox of her husband's lover to get back at her. It caused superficial injury to the hand, and she was charged under the Chemical Weapons Treaty Act. Now, that's just not right. We have a case pending right now in the 11th Circuit called the Clay case, in which a legitimate dispute about the interpretation of Medicaid reimbursement provisions, a legitimate, honest dispute which lawyers couldn't even agree about, resulted in the federal government prosecuting and the business operators and subjecting them, ultimately, if they don't prevail on appeal, to several years in prison. And more recently, we have a new salvo from the Department of Justice, and that's the Yates memo. Mark, I think you're going to have to get to work pretty soon on the fourth edition, because that happened after the third one went to print. But the Yates memo is a new Department of Justice policy that provides that corporations will not be able to resolve investigations unless individuals are offered up for criminal prosecution. Now think about that. What if you have a situation where no one person has complete knowledge of facts that would constitute a crime? You have A who knows a fact that is not criminal, B knows another fact, not criminal, C knows a third fact, not criminal. Collectively, there is an argument that the corporation had criminal liability, but no one person had that knowledge. Think about how that might play out. Will the entire company be brought down because no one person can be brought up? Will there be a tendency to make someone who did not have guilty knowledge a fall guy in order to save the company? Is this the way the criminal law should operate? I don't think so. We need to cabin our criminal laws and the misuse of the criminal process. We need to prevent the use of the criminal process to extort huge financial settlements in something that at most is a regulatory violation. We need to not use those potential penalties from a criminal prosecution to resolve what may be a winnable civil issue. And we need to ensure that the average person is not afraid to be an entrepreneur and pursue those innovative ventures that are the hallmark of America as a land of opportunity. The timeline is not going to produce change overnight, but it is a very important tool in highlighting these issues for lawmakers, for public policy advocates, and for the general public. I'm extremely grateful to the Washington Legal Foundation for this, and I thank you for the opportunity to endorse it and embrace it and use it in our work.
Thank you very much, Jay, Norman, for your excellent remarks. And thank you, too, for holding up the timeline, which is something I neglected to do at the beginning, Norman. When you said that a picture is worth 1,000 words, I thought you were going to say, especially when the picture contains 1,000 words. So I don't know what the word count is in the timeline, but in any event, there is a whole lot of good information here. And I wanted to begin my remarks by saying thank you to Corey Andrews, Senior Litigation Counsel here at WLF, who really led the research effort, not only on this third edition of the timeline, but going back to the last edition as well. And this product wouldn't be here for us to use without Corey's excellent efforts. So I wanted to single him out for that. I also wanted to let people know, as the remarks are coming to an end, if they wanted to ask questions. And Glenn, is it interactive@wlf.org? Is that the correct? I'm getting a head bob, yes. So interactive@wlf.org if you have a question that you'd like to address to one of the folks on the panel. Overcriminalization is a term that came into vogue about 10 or so years ago as a catch-all phrase to describe several interrelated legal policy problems. Washington Legal Foundation has been at the forefront of the debate on overcriminalization, helping to both popularize the term and offering thought leadership to policymakers, judges, and other participants in the criminal justice system. One concrete manifestation of this leadership is the new third edition of the timeline, which tracks the federal erosion of business civil liberties. The timeline explores 6 facets of overcriminalization. First, inadequate mens rea requirements and over-reliance on public welfare offenses and the responsible corporate officer doctrine. Second, criminal enforcement policies and practices at the Environmental Protection Agency. Third, criminal enforcement policies and prosecution practices at the Department of Justice. Fourth, infringements on the attorney-client privilege and work product doctrine. Fifth, abuse of deferred prosecution and non-prosecution agreements. And last but not least, the proliferation of criminal laws and unduly harsh sentencing provisions. By arranging the various developments in these 6 areas in chronological order and in chart form, I think the timeline helps to illustrate negative overcriminalization trends. For example, in the mens rea row, it becomes rapidly clear that Congress is a major part of the problem. The Fraud Enforcement and Recovery Act of 2009 amended the False Claims Act to eliminate the intent to defraud requirement from the act. The Dodd-Frank Act in 2010 expanded SEC's ability to try wrongdoers for conduct that is merely reckless. And the Patient Protection and Affordable Care Act of 2010, better known as Obamacare, reduced the criminal mens rea needed to prove healthcare fraud. Nor is this a one-party problem. Although it happened too recently to be included in the timeline, as Norman mentioned, it's worth mentioning that the bipartisan criminal law reform bill in the Senate omitted mens rea reform, including even the very basic idea of a default mens rea provision that would apply to statutes or regulations that do not otherwise specify the level of intent necessary to prove a criminal offense. In the EPA criminal enforcement policy row of the timeline, the agency's decision to hire 200 new civil investigative demand agents and to curtail the agency's highly successful self-audit policy show a preference for traditional enforcement over achieving positive environmental results. In the DOJ criminal prosecution policies row, there are several examples of cases that never should have been brought. Norman mentioned these. A defendant who put a household chemical on someone's doorknob and then charged with a violation of the Chemical Weapons Convention Implementation Act to the fisherman, Mr. Yates, who was charged under the Sarbanes-Oxley Act. But I wanted to underscore one particular fact about these cases, which is not just that prosecutors seem intent on overcharging, but the Department of Justice itself seems willing to pursue these misguided cases all the way up to the U.S. Supreme Court. And that raises the question, where is the adult supervision when this overcharging occurs at the single prosecutor level? The latest example along these lines is the current indictment against FedEx for, quote, laundering money and, quote, conspiring to traffic in controlled substances because it delivered some packages containing prescription drugs to customers of internet pharmacies. In other words, laundered money, it was paid for delivering the packages, and conspiring to traffic in controlled substances because it had a business relationship with the person who sent the package. That's not criminal activity in any way, shape, or form, and yet it's being charged that way by the Department of Justice as we speak. We also have seen the Department of Justice using the mere threat of criminal prosecution to exert its influence in Operation Choke Point, trying to deprive completely lawful businesses like firearms stores, like payday lenders, of the ability to have a bank account necessary to run their business. The attorney-client privilege area continues to be one of concern as well, and here too, the Yates memo that Norman mentioned comes into play. The increased focus on prosecuting individual corporate officers that memo portends will inevitably bring back the concerns that were sharpest about a decade ago when DOJ was last making the prosecution of white-collar crime a priority second only to terrorism prosecutions. Because corporations do not have Fifth Amendment rights against self-incrimination, a favorite tactic of prosecutors has been to target a corporation to obtain documents that would not be available from just targeting individual defendants, and then to go after specific individuals who are allegedly incriminated by those documents. To the extent that the Yates memo envisions pressuring companies to turn over more information about potentially culpable individuals, this end running of individuals' Fifth Amendment protections is bound to recur. When it comes to deferred and non-prosecution agreements, the unmistakable trend is the DOJ is coming to rely on them more and more heavily. As the timeline points out, there were only 18 DPAs or NPAs total, 18 total between 1993 and 2002, a 9-year period, about 2 per year. Since then, there have been an average of more than 17 DPAs or NPAs each and every year. The question arises how often these agreements are causing companies to buckle who might otherwise, if pressed to defend their actions in court, prevail against overly aggressive interpretations of governing statutes. For example, in connection with a non-prosecution agreement, UPS forfeited $40 million to settle DOJ's probe into its shipments on behalf of online pharmacies. If FedEx ultimately prevails in its case, as I hope it will raise a strong concern that UPS paid a stiff criminal penalty for doing something that was not illegal. A $40 million penalty for doing something that a court would have found in another case is not illegal. Finally, in the realm of proliferation of criminal laws, the timeline notes that 439 new criminal offenses were added to the books from 2008 to 2013, a pace of almost 1.5 new federal crimes every single week. And even this scary high number vastly understates the problem, as it only counts offenses in the U.S. Code. The innumerable new criminal penalties created in the Code of Federal Regulations by federal regulatory agencies further compounds the problem. On the bright side, the House of Representatives made an internal rule change at the beginning of this year to give the House Judiciary Committee concurrent jurisdiction over any bill containing criminal penalties. It will be interesting to see in future years and perhaps future iterations of the timeline whether that check on runaway legislation slows the growth of new criminal laws or not. Overcriminalization developments continue to occur at an alarming pace, as demonstrated by the couple of examples mentioned above that happened after the timeline went to print. But Washington Legal Foundation will continue to cover these topics adroitly. We expect that the federal erosion of business civil liberties timeline will serve as a useful way to identify, track, and contextualize overcriminalization problems that arise in the months and years ahead. Thank you for tuning in today, and we'll throw it open to any questions.
The Yates fish case in the Supreme Court. I vividly remember Justice Scalia during oral argument being quite incredulous when he asked why this particular criminal charge had been brought, and what the prosecutor said was, well, it's the policy in our office to look at every potential crime and to always charge the one that has the longest criminal sentence attached to it as a way of pressuring a guilty plea. And so they figured out that this Sarbanes-Oxley statute had a 20-year sentence attached, so even though it was a questionable charge, they figured, well, why not go forward with the greatest charge we can? And I'm wondering, is that really the Department of Justice policy to always charge the offense that has the longest potential sentence attached to it? And if so, is there any move afoot to suggest that maybe that is not a proper policy?
Well, shall I start?
Sure.
First of all, I think that hits upon a couple of very interesting issues, and as Mark suggested, one of the big problems is the lack of adult supervision. In some areas, the Justice Department had been the clear policy across the board to charge the highest provable count that you could. To some extent, the Justice Department in some areas, with some memos that Eric Holder issued, has backed off. But that is not, where is the adult supervision? That's not binding. Each prosecutor, each district does what it feels is appropriate. But really what this is wrapped up in, and it's really when you dig into the facts of the Yates case, you will see this. This is another problem which we have in our system, which is what we call the trial penalty. The use of different tools to force people to plead guilty. We now live in a country in which 97% of all criminal cases are resolved without a trial. That is not because 97% of all cases have people who are guilty. People are afraid to go to trial. What happened in the Yates case was when Mr. Yates wouldn't plead guilty early on, they ratcheted it up by bringing in, by this creative use of a statute that was clearly aimed at the destruction of documents when a pending investigation was underway. Same thing could be said in that Bond case. They used that as a tool rather than a simple assault charge. It is a total misuse of, in my judgment, it is a total misuse of the criminal law to force people into giving up a fundamental right to try their case. Especially in the area, especially in any area where it deals with intent, and most white-collar economic regulatory matters deal with intent. In those areas in particular, a person should have the right to have a jury of their peers decide whether, in fact, they had a guilty mind when they committed a crime. They shouldn't have to give that up out of fear that the consequences will be geometrically increased. That's exactly what happened in Yates. Scalia was right to bring that up, and a lot of people now are beginning to take a look at the whole concept of the trial penalty.
The other thing I would throw in about the Yates case in particular, and this didn't come out at the Supreme Court so much, but the backstory, part of the backstory of that case is prosecution shopping. The folks in the Fish and Wildlife Service who initially were the ones who discovered or who apprehended Mr. Yates in the Gulf of Mexico and who had at their disposal the ability to fine him and charge him under various fisheries provisions, decided that they wanted to pursue him under a much stiffer penalty. They took this to at least one other federal district division, U.S. attorney, and who turned them down, or division within the, right, because there's more than one city, more than one division within the Middle District of Florida. And one of those turned them down and said, this isn't a case that we want to bring. And so then they shopped it to a different division within the Middle District of Florida, maybe one that was less busy, I don't know, but who was willing to then bring the case. And that's, I think that's a troubling aspect of that particular case as well.
Got a question from an online viewer. It sort of picks up on what you were saying, Mark, which is how much of an impetus for criminal cases that may be better treated as civil or administrative cases come from the administrative agencies themselves, and is there enough of a check at the Justice Department or in the U.S. Attorney's offices against that sort of inertia or momentum to try to bring a case criminal coming from the administrative agencies?
This is Jay. I might comment on that briefly. One is cautious about trying to project what the views and policies and practices of a whole range of agencies may be. But I think there is a sense that there is almost sometimes a competition among agencies, or there is a drive within an agency to establish its bona fides as a strong enforcer of the law. We've seen a proliferation of law enforcement authorities through administrative agencies, which that might actually be an interesting timeline piece to put on the Washington Legal Foundation's timeline, where whether it's arming agents, whether it's giving authority, litigation authority to agencies, etc. But you do see sometimes, at least in my experience, where an agency has a very parochial interest in ensuring the investigation and prosecution of a particular violation of its regulatory laws. And sometimes the Department of Justice may actually serve a bit as a modulator on how that happens. Other times it may be that there's a real drive by the agents at the agency or the officials at the agency to get their case prosecuted. And in the governmental process, there is a push and pull, a tugging that goes on to decide what should the policy be, and there may well be more deference to the agency than perhaps there should be, because the role of the Department of Justice would be to ensure that there is some uniformity as to the application of the law. It is the Department of Justice, it's not the Department of Prosecution. And it could be useful and important, particularly in the discussion we just had previously about, do you charge the most serious offense provable? But you also somebody needs to make a judgment. Is this the kind of case that should be prosecuted at all? And is this the kind of case where the crime that is sought to be charged is actually relevant to the conduct, as in the chemical issue on the doorknob kind of case, or even in the Yates case? So the underlying answer is this is an area that I think the Department of Justice can exercise responsibility, but there is within a growing government where more and more agencies have more and more authority to prosecute more and more criminal cases. There is an urge to sort of establish themselves as strong in their regulatory enforcement, and so the Department of Justice can either be a bit of a break on that, or at least a modulator to ensure that cases that are brought meet the standards of justice, as well as meet the elemental requirements about whether or not this really is a crime and whether this is an offense that should be prosecuted as a crime.
I think that's a great point, Jay. And to that same question, but before I say that, interactive@wlf.org is the email address if you want to ask a question. Interactive@wlf.org. There's a specific example from an administrative agency on the timeline. May 2013, in the mens rea row of the timeline, talks about an incident at the Consumer Product Safety Commission. And what it indicates on the timeline is that the responsible corporate officer doctrine was invoked in order to name the CEO of a company called Maxfield and Overton, the maker of buckyballs, the little BB-sized super powerful magnets, in a recall. The company had not broken any laws, it hadn't broken any regulations. In fact, it had worked with CPSC on the warning label that was to appear on the product. Notwithstanding that, the agency still wanted the product off the market. The company refused because it was the only product that the company made, and it didn't want to stop making it. The agency then went to the companies that distributed the product, like a Brookstone or other companies that made that product available, and threatened them if they didn't take the product off the market, thus depriving the company of revenue and forcing it to rely solely on internet sales on the company's website. But I want to focus in on the fact that the charging decision was made in this case when Maxfield and Overton went bankrupt as a result of these activities. It set up a little bit of a fund to pay for any recalls that came about. Of course, there weren't many recalls because the people who purchased this product wanted to keep it. I'm the proud owner of some buckyballs, as a matter of fact, and I certainly didn't send mine back in for a recall or for a refund. The agency thought that there wasn't enough money in that fund, and that the only way to get more was to name the CEO personally. And they did so under the responsible corporate officer doctrine, except that, again, to repeat, there had been no regulatory violation, certainly no criminal violation by the company, and therefore you would think absolutely no hook for the responsible corporate officer doctrine to be used in this case. However, the charging decision was made not at the 5-commissioner level of the CPSC, but was made by staff at the CPSC. It wasn't even voted on by the commission, which I think was a travesty. And furthermore, when that case made it in front of the ALJ, the administrative law judge, the ALJ allowed that responsible corporate officer doctrine charge to stand against the CEO and forced a settlement with the CEO in the case. So a very bad example from the questioners from the administrative agency of where prosecutorial power was abused there as well. Well, Norman and Jay, I want to thank you very much for being here today and helping to spread the word about the overcriminalization timeline, and look forward to working with you in the future on spreading the message about this problem, and hope that everyone gets as much use out of the timeline as NACDL. Thank you for joining us today. Terrific. Thank you very much.
Really enjoyed meeting you. Thanks again for coming.
Absolutely.
Great job. Thanks. As always, great quarry. Pleasure.
I do not have a card with me. I apologize. How about you?
I don't.
Why don't you just give me an email. I'll send you an email. Okay.
How about I send both of you each other's contact information since I have both of it?
Okay.
Would that be okay?
That'd be great.
Okay.
Thank you. Thanks so much. Really. Love to get you on one of our programs.
Good comment. Whether you're a prosecutor or